Ladies and gentlemen, I'm so excited. And let me first of all thank you, my cherished viewers, for your loyalty, for your patience, for your support, and for your love. Without you, this program cannot go far. We are in it together. Ladies and gentlemen, that was the voice of the king of Mampurgu, the Nayiri. The first the first audio you listened, where there was a Drummond giving appellation to the king, basically recounting historical facts about his lineage, both maternal and paternal, and the good works of his father and those before his father. The second one also was when his fellow brothers from Dagbon, his younger brothers, I must say, from Dagbon, came to him to plead with him to forgive those lost souls who went to Abugrago before going to Puzga, claiming to be tracing their roots. The second audio was that one. And they were pleading with the king also to talk to his son, the regent of Bogu, to forgive the drummer who also misbehaved in giving that appellation to Abugrago, something he didn't deserve, ladies and gentlemen. And you know, one thing I love about this is that, you see the way they were clapping. That is how chiefdom is done in Mamprugu. The way the mamprusis clap before the chief, when you observe it, you see far difference from what you witness when those dance group visited Zoguran. I'm emphasizing this. Chiefdom is for chiefs, and pacification of the gods is for Tindanis. Ladies and gentlemen, on that note, let me go straight to what we need to know today. The topic for today is titled Understanding the Genesis of the Chieftaincy Dispute in Bawku. I'm going to give you the facts, and I've made it very simple, very coherent for you to understand. Ladies and gentlemen, if you don't understand this, and you want to understand the Supreme Court ruling, you are doing a disservice to yourself and to all those who need to know the genesis of the dispute in Bawku. The Supreme Court ruling, to me, is nothing serious. We'll look into that, but it's nothing serious. It doesn't end anything. let's look at the beginning before we come to where we've reached now. That is very, very important. And that is why history is very, very important. And that is why people without history are struggling, are having problems when we talk about history. I know my father, I know my father's father, and I know my father's father. My father's father, I know. Not everybody can trace their roots. So that is one thing that Mamprugu we have to be proud of, ladies and gentlemen. Now, let me just go straight forward. 300 years ago, Chieftaincy institution was established in the Bawku traditional area by Na Atabia, one of the many late kings of the Mamprugu kingdom. Na Ali Atabia, son of Na Atabia, was installed by his father as the first chief of Bawku in 1721. The Bawku traditional area is one of the many traditional areas under the Mamprugu kingdom and the authority of the Nairi. From 1721 to 1956, 235 years pre-independence, the Bawku traditional area had 12 chiefs from the mamprusis royal lineage, and Bawku was peaceful, vibrant, with unity, cooperation, and understanding existing among all the ethnic groups, including the kusasis, who knew their history and the history of chieftaincy in Bawku. My grandfather Mbawuni Bugru, also known as Nasa, was the last chief before Ghana became an independent nation from British colony. He died on December 10, 1956. And after the performance of his funeral, his cousin Nair Salma, also known as Nair Mahama, also known as Na Salma, Salma here means gold, and Sa means rain. So Nair Mahama, Na Salma, was installed by the then Nairi in 1957 as the 13th paramount chief of Bawku. Ladies and gentlemen, then in 1958, chieftaincy dispute ensued between the mamprusis and the kusasis. It started when one day the kusasis at a political rally of the CPP, that's the Convention People's Party in Bawku, and attended by Dr. Kwame Nkrumah, introduced one Aburago Asigiri Azoka as leader of the Kusasi Youth Association, and later as the Kusasi chief of Bawku, thus usurping the authority of the legitimacy of the legitimately installed chief of Bawku with royal lineage. And for the first time in over 200 years, the chieftaincy institutions in Bawku experienced something alien. It is worth mentioning that the set Aburago Asigiri Azoka, now late, was a sandal bearer of Na Salma, the 13th paramount chief of Bawku, and is believed to be a Yanga by tribe and not a Kusasi, who came to Bawku around the 1940s. Ladies and gentlemen, Aburago Asigiri Azoka is the father of the current chief of Bawku, Aburago Azoka II, also known as Zogran. That same year, in 1958, the last Governor General of the Gold Coast, Lord Listowel, set up a 3-member commission of inquiry to look into the chieftaincy dispute between the mamprusis and the kusasis and make recommendations for consideration. It is said that the commission's findings was presented to the assembly then, the General Assembly then, as we call Parliament today. Then, and both Na Salma and Abogrago Azoka were asked not to carry themselves as chiefs. Na Salma, however, rightfully being enskinned as the 13th chief of Bawku, could not resist carrying himself as a chief because he was a chief. Continued to hold himself as a chief of the Bawku traditional area. And for that reason, the CPP government, led by Dr. Kwame Nkrumah, directed that Na Salma should stay away 30 kilometers from Bawku. Ladies and gentlemen. Consequently, forcing him to exile in Togo. It is also said that the commission recommended that the kusasis ought to be chiefs of the Bawku, according to the kusasis. And a white paper was issued by the government in that regard, the CPP government. Ladies and gentlemen, the mamprusis took the matter to the High Court, and the court decided in their favor. That is, the mamprusis are the rightful people to be chiefs in Bawku. But it didn't end there. The kusasis also appealed against the High Court decision. Interestingly, the High Court, the appeal court, reversed the High Court decision, thus making Abogrago Azoka considered or regarded as the chief of Bawku. Ladies and gentlemen, all these events occurred or happened in 1958, a year after Na Salma was enskinned as the legitimate chief of Bawku by the then Nayiri. Sadly, Nayirmia died in 1962. Then in 1966, the National Liberation Council, LLC, led by Colonel E.K. Kotoka, overthrew the CPP government. It must also be mentioned that Na Salma was forced into exile partly because his people, the mamprusis, did not support the CPP during the struggle for independence. The mamprusis instead solidly and wholeheartedly supported the United Gold Coast Convention, led by Dr. J.B. Donkwa. Same as the mamprusis are doing now, investing their support in the new patriotic party without commensurate dividends in return. Ladies and gentlemen, according to the Kusasi Youth Association as contained in their press release of December 12, 2021, in page 13 of the commission Lord Listow set out, it is stated that the Nayiri's practice of selecting and installing a Mamprusi prince as chief of Kusasi area is undemocratic and dictatorial. Ladies and gentlemen, I brought this in as sharing facts with you because I just want to capture in the version of the Kusasis, just to give them that objectivity. But of course, we will get to know the truth. So that is the kusasis version. Ladies and gentlemen, following the overthrow of Dr. Kwame Nkrumah, the NLC administration passed a decree, NLC 112, restoring the enskinment and installment of all chiefs in the country the CPP government deskinned, including Na Yurmia. Consequently, Abogrago Asigiri Azoka was deposed as a chief. Once again. Na Salma's funeral was performed, and Na Zangbeo's, also known as Na Tampuri, enskinned by the then Nayiri as his successor and the 14th paramount chief of the Bawku traditional area in 1967. Interestingly, Na Tampuri, the 14th paramount chief, ruled for 14 years. Before his death, he died in 1981. The year the Provisional National Defense Council, PNDC, led by Jerry John Rawlings, overthrew the People National Party, PNP, government of Dr. Hilal Liman. It must also be mentioned that, like the CPP, the mamprusis were not sympathizers of Rawlings' coup d'etat. Ladies and gentlemen, in May 1983, the kusasis took the matter to the regional House of Chiefs. Then, Na Zangbeo, the late Na Zangbeo, the father of the current regent of the Mamprusi, was the chief. Remember, he was enskinned in 1967. So all the way after 1967, any events that I'm going to narrate to you, have in mind Na Adam Zangbeo. So in May 1983, the kusasis took the matter to the regional House of Chiefs for redress, basically challenging the legitimacy of Adam Zangbeo as the rightful chief of Bawku. While the case was still pending there at the regional House of Chiefs, the kusasis also went to the High Court in July that same year, seeking to annul NLC 112. Ladies and gentlemen, I must state that prior to 1983, in 1980, that was actually what happened. The kusasis took the matter to court. It was in 1980, prior to 1983, but it wasn't in their favor. So in 1983, they took the matter to the regional House of Chiefs, and they, at the same time, took the matter to the High Court, seeking the same thing. The High Court dismissed the case for lack of jurisdiction, since the matter was still pending as the regional House of Chiefs. Ladies and gentlemen, the regional House of Chiefs also ruled in favor of the mamprusis. The kusasis, led by Abogrago Azoka, again went to the National House of Chiefs. Not satisfied by the dismissal of the High Court and then the ruling of the regional House of Chiefs in favor of the mamprusis, they went to the National House of Chiefs in 1983. Again, for redress. Ladies and gentlemen, there too, the kusasi lost. And Abogrago Asigiri Azoka, also known as Zogran's father, Abogrago Asigiri Azoka, then in 1983, was described as a commoner. And he died in 1983, the same year. That's the same year. So we start from 1721 when chieftaincy was established in Bawku. Then we come to how the Kusasi began claiming that they were chief, or they are entitled to chieftaincy in Bawku. The current chief's father was introduced at a political rally as leader of Kusasi Youth Association. That is how they started. And later on, described, considered, or regarded as Kusasi chief of Bawku. That was in the 1950s, 1957. So, bringing in dispute, right? A commission was set up by the colonial masters, even though Nkrumah was also the president at the same time. The matter was looked into. Long story short, both of them were asked not to hold themselves as chiefs. The legitimate chief, Salma, couldn't resist because it is in his blood. He was in skins, rightfully. He's from a royal lineage, so continued to carry himself as chief. The CPP government therefore decided to ask him to stay away 30 kilometers away from Bawku. And he has no choice than to move to Togo on exile. He died there. In his absence, the kusasis, the mamprusis took the case to High Court, and they won. The kusasis appealed, and the kusasis won. All this in 1958. Then came NLC, a military regime. And when LLC came, LLC sought to restore the original chiefs across the country, chiefs that Nkrumah distilled, back to their original status. That gave room for Adam Zangbeo to be installed as the Bawku Naba in 1967, 10 years after the death of Yirmia. Ladies and gentlemen, then of course a series of cases that the kusasis initiated to get restoration back to them, but they lost in all those cases. The only case they won was an appeal case. And the appeal case, to the circumstances was that the mamprusi, the defendant wasn't there to make his case and all those kind of things. But long story short, they won the appeal case. Then, ladies and gentlemen, let's transition to the popular PNDC Law 75. No, from 1981 all along, that was Rawlings' regime. But in 1983, all that was happening, the PNDC did not poke its nose into all this until 1984, when John Ndebugri, who was actively with the PNDC, and then secretary for the upper region, in helping his people, initiated and got the government to pass PNDC Law 75, titled Chieftaincy Restoration Statutes of Law 1983, actually 1983, PNDC Law 75, so the same year, 1983. Ladies and gentlemen, consequently, since 1981, the death of Adam Zangbeo, the mamprusis have not been able to perform the funeral of their late chief. And now they want to do that this year, 2021. However, and very much sadly, I hate to say this, but I must say it, the Bawku Divisional Police Commander and other forces succeeded in preventing the mamprusis from performing the funeral so far. Ladies and gentlemen, I will read to you what PNDC Law 75 is about. And PNDC Law 75 is, so this is PNDC Law 75. It says Chieftaincy Restoration Status of Chiefs. The law, whereas by virtue of Section 3.1 of the Chieftaincy Amendment Decree 1966, NLC 112, the then government of the National Liberation Council withdrew recognition of the persons named in Part 1 of the schedule to this law as chiefs in the places specified respectfully in relation to them, etc., etc., have been restored to their original status as chiefs of their respective places, and they are Azoka Abugarago for Bawku and other 15 chiefs for their areas too. The same law withdrew the recognition of Alhaji A. Azangbeo as Bawku Naba and other 15 chiefs at their respective areas. That was long after 2 years after Alhaji Zangbeo died, ladies and gentlemen. So basically, PNDC Law 75, let me use the word, repealed NLC 112, which then gave the kusasis the opportunity to hold themselves again as chiefs, ladies and gentlemen. And now came the Fourth Republic in 1992. During the Fourth Republic and coming into being the 1992 Constitution, in 1996, PNDC Law 75 was repealed by Act of Parliament, titled Statute Law Revision Act 1966, Act 516. What it therefore means is that since PNDC Law 75, the law that restored chieftaincy to the kusasis, since that was repealed in 1996, what it simply means is that the recognition of Abugarago Azoka was also open for challenge. Let me put it that way. The legitimacy of Abugarago Azoka was open for challenge. That is the legal implication. Then came in 2003. Unknown to the mamprusis, that PNDC Law 75 was repealed in 1996. They went to court seeking to do what? Seeking to get the court annulled. Let me use this word, the efficacy of PNDC Law 75. Because that was a law that restored chieftaincy back to the kusasis. So it was the understanding of the mamprusis that just as NLC 112 was repealed, we also have to ensure that PNDC Law 75 is repealed. Then we can build our case. So the mamprusis didn't know that, and they went to court. They went to court, and it was there that they were told that they went to the Supreme Court, and they were told that the law that you are seeking to repeal has already been repealed. Ladies and gentlemen, that was what the Supreme Court told them. So, what the mamprusis could do at that time, through their counsel, was to apply to the court to discontinue, to withdraw the case, because they went for a simple case. They went seeking to annul or repealed PNDC law 75. And they were told that that law has been repealed. So logically, or legally also, the best decision to take is to withdraw, because there was no case again for you to pursue. So the mamprusis applied. Before I continue, let me make this straight. When I say there was no case to pursue, let's understand that the case was about PNDC law 75. Simple and short. Nothing beyond that. It was about PNDC law 75. So since PNDC law 75 was repealed, then there was no case for the mamprusis to pursue. So the best thing to do is to discontinue or withdraw and re-strategize and come back again. So the mamprusis applied to the court. Okay, we want to discontinue with this case with the liberty to apply again. What was the court decision? The court decided that the discontinuation will be granted, but the liberty to apply denied. I'm looking for the ruling so that I will read it, and then we can cure the propaganda and the misinformation. So it says that application to discontinue granted, but without liberty to apply under PNDC Law 75 and Section 270 and 277 of the 1992 Constitution. First of all, I'm not a lawyer. Many of you, I believe, are not lawyers. Bombande is not a lawyer, but all of us are talking about this. So we are all giving our layman understanding of the ruling. For me, it is important to state that I'm not a lawyer because I don't want to be seen doing the work of a lawyer. At least the little training that I have. If you are not, it is unethical for you to carry yourself as a lawyer when you are not a lawyer. So I want to state that I'm not a lawyer. However, that does not prevent me from making comment or giving my understanding of the ruling. So the court said the application to discontinue is granted, but without liberty to apply under PNDC Law 75 and Articles 270 and 277 of the 1992 Constitution. To me, this is simple. It said, we've granted you the application to discontinue, but we are not granting you the liberty to apply again under what? PNDC Law 75. Again, which has already been repealed. So what is the point? You understand? Then Article 270 basically talks about the powers of Parliament. Powers that Parliament cannot, let me put it this way, things that Parliament cannot do under the Constitution regarding chieftaincy. Article 270 has nothing to say that the mamprusis cannot take the matter to court again. No. It is only talking about Parliament, what Parliament cannot do. Parliament cannot enact law to do what Parliament cannot distill this, Parliament cannot. That is what it's saying. And it is based on the experience of previous regimes and how governments have, misbehaved, let me use that word, with chieftaincy institution. Now, what is Article 277 saying? Article 277 is basically defining who a chief is. You understand? So, To me, the issue, considering the ruling, the issue we all ought to be asking ourselves is whether the mamprusis, whether or not, let me put it that way, whether or not the mamprusis can bring civil action against Zogran, challenging his legitimacy to hold himself as paramount chief of the Bawku traditional area, notwithstanding the Supreme Court ruling. For me, that is the issue. The Supreme Court ruling is very specific. Don't come to us again based on PNDC Law 75, based on Article 270 and Article 277. It did not say you cannot pursue the matter anywhere you want to. It is simply saying for us, the Supreme Court, don't come to us again on these three laws. One has already been repealed, two are in the Constitution. And as I said, Article 270 is about Parliament. Nothing about don't bring, is about Parliament. 277 is about the definition of a chief. Now, we need to understand, because the wisdom behind the decision of the Supreme Court, if you relate it to the decision of the High Court in 1983, when the kusasis took the case to the Regional House of Chiefs and then also to the High Court. The High Court said, we don't have jurisdiction to handle this. Basically, the right place is the Regional House of Chiefs. If you are not satisfied with National House of Chiefs, from Regional House of Chiefs, you go to National House of Chiefs. So to me, this is my understanding. The wisdom behind the Supreme Court ruling, what the Supreme Court is saying is that don't come to us arguing on Article 2, PNDC Law 75, Article 270 and 277. My dear brothers and sisters, that does not take the right of the mamprusis away to pursue this issue if they so wish in any other avenue, especially the National House of Chiefs, starting with the Regional House of Chiefs. Starting from Regional House of Chiefs. Because that institution is for the chieftaincy. And that is where issues relating to chieftaincies are addressed. So when people say the Supreme Court ruling has put finality to the case and the mamprusis cannot do this, it's not true. It's not true. If the Supreme Court had said, in addition to this, has said that you cannot bring a case against Zogran in any court or any institution, let me also put it, any institution that has a jurisdiction to deal with chieftaincy issues. If the Supreme Court has went further to say that or to add that, to me, that is where the worry would have been. But in the wisdom of the Supreme Court, as I understood the ruling, they understood that there is what is called the Chieftaincy Institution and the Chieftaincy Act dealing with chieftaincy matters. So for the Supreme Court, understand their role. The role of the Supreme Court is just to interpret laws. So they don't want to put themselves into the above chieftaincy matters. It is when you go to the Regional House of Chiefs with your case and you are not satisfied, the next place to appeal is the National House of Chiefs. When at the National House of Chiefs you are not satisfied for whatever reason, I believe that then you can then go to the Supreme Court. on the substantive issue, that is the legitimacy or otherwise of a chief. But what the mamprusis did in 2003 was just to get PNDC Law 75 repealed. And they were told that it is repealed. So that's it. I believe the mamprusis wanted to get that repeal. After repealing, then they would then go to the right avenue, using the National House of Chiefs to get their matter handled. So, ladies and gentlemen, if Bombande or any other person tells you that the Supreme Court ruling has brought finality to the case and the mamprusis cannot do this, and it is not true. At least from my understanding, it is not true. Ladies and gentlemen, it is propaganda. It is propaganda. The mamprusis can pursue the case whenever they want at using the national, the regional and national House of Chiefs. Ladies and gentlemen, so these are, I would say, some of the facts about the genesis of the Bawku chieftaincy dispute and the reality. The reality is that the Supreme Court ruling in 2003 only limit the mamprusis from coming to the Supreme Court under PNDC Law 75, under Article 270 and Article 277. And I'm saying that PNDC Law 75 has already been repealed, so that is not a headache. Article 270 is basically stating what Parliament cannot do regarding chieftaincy. The mamprusis are not claiming to be Parliament, so the mamprusis they don't need to bother themselves about Article 270. They don't need to bother themselves about Article 275. They don't need to bother themselves about Article 270. Now let's come to Article 277. Article 277 defines who a chief is. The mamprusis too are not challenging the definition of Article 277. In fact, the definition of Article 277 actually goes in favor of the mamprusis. You see, so to me, the ruling is just to tell the mamprusis that don't come to us to pursue the case on these three laws, but it doesn't mean that if you find other avenues that you can pursue your case, we are preventing you from doing that. That is not the ruling, ladies and gentlemen. That is not the ruling. To the best of my knowledge, that is not the ruling. So we shouldn't allow anybody to mislead us. And trust me, if you talk to lawyers, if you talk to 2, 3, 4, 5 lawyers, they will all give you their different, their opinion about this ruling. It might differ. And that is the beauty of the law. That is the beauty of the law. You know? And then so the other thing is that even the Supreme Court ruling, the Supreme Court can review its own ruling. So even if it is assuming that indeed it is against the mamprusis could still apply for a review. But I'm just stating this just to broaden the understanding of legal issues. Now, so ladies and gentlemen, let me take this opportunity to correct some mistake I did yesterday. And one of our brothers, Tohogo, he pointed out to me yesterday, there and then, that my position that the Supreme Court ruling is not a law is wrong. It's true. I have done my research, and Tohogo is true. It's right. Supreme Court ruling and a court ruling in general, for that matter, are laws. But these are what we call case laws. When it comes to law, you have the Constitution is a law. We have statutes are also laws. Regulations are also laws. Court decisions are also laws. But court decisions are what we call case laws. And all these fall under what we call primary source of laws, or primary sources of law. So I just want to admit that I was wrong yesterday when I said it isn't a court ruling, isn't a law. It is a law. I think what I mixed up was, I was looking at it from the government point of view, where we were taught that Parliament makes law, the court interpret laws and all that. So I was coming from that angle. You understand? But in the judiciary, let me put it that way. Yes, court rulings are case laws. So law is law, ladies and gentlemen. So basically, that's it. That's it. Now, let me see if I can answer some question that any of you might have on this matter. Okay, you said Buddy Gamsira, you said following you live from Tamale. We are proud of you. Okay. I'm trying to see if there's anything that any of you will want me to explain. Sumbe the Arcombe said, I hope Imam Bombande, the lawyer of Kusao, is listening. Don't mind that Bandacoot. Yeah, so ladies and gentlemen, in 8 minutes time, I would end today's session. But to me, the most important thing is that we need to understand the genesis of the chieftaincy dispute. If you don't understand the genesis and you are interested in Supreme Court ruling, you may be doing disservice to yourself. You may end up, when you even want to educate somebody, you may be misleading that person. Just like Bombande did by saying that the Supreme Court ruling is more or less, not more or less. I'm trying to make it look nice for him when he said the Supreme Court ruling has brought finality to the issue. And then one embarrassing thing he said was that regarding the PNDC, he said PNDC came as God sent to correct the injustice and evil doing of the NLC. The evil doing started in 1957 under the PNDC, the CPP government. Went in Kurma, distilled many chiefs across the country, not only Bawku. In Bawku case, we are only talking about Bawku because Lord Listowel Commission sat on it. Even that commission, I don't want to talk about the detail and what happened of that commission, but the point is that Lord Listowel Commission, Lord Listowel set up a commission that sat on it in Bawku. But across the country, the CPP distilled many chiefs. Many chiefs. So that is the beginning of the evil. And LLC came and restored chieftaincy to their original owners. So, if I'm going to say, talking about God sent, if I would say God sent an administration at all, a regime to come and correct the evil, then the NLC administration is the best to describe as God sent. But when you follow the history of Bawku, now limiting it to Bawku, if you follow the history of Bawku from 1721 all the way to 1956, there has never been chieftaincy dispute. There has never been conflict. There has never been gunshot and all those kind of things. It was in 1957, under the PPP government, that all this started. That's the root of the evil. Ladies and gentlemen, breaking news. I just got a report from one of my reporters on the ground that there were some gunshots around Misiga area, and a car was burned. The identity of the driver is unknown right now to me. His tribal affiliation is also unknown to me. So I cannot state anything about that as a fact. But what I can state as a fact is that there were some gunshots around Misiga area. And a car, I'm told, was burned, set ablaze, ladies and gentlemen. And that is sad. And let me use this opportunity to say that if the regional minister, and for that matter, the regional security council, lift the ban on wearing smoke in Bawku because of the summon paid, and there should be any disturbances in Bawku, the regional minister should be held responsible. Because the reason the regional security council gave for imposing the ban on wearing smoke is as relevant as it is the very day the ban was imposed and now. The reason given, because it said people hide guns and ammunition in the smoke and create troubles. We all know that the festivals in Bawku, be it Damba, be it Samanpit, whatever, Zekula, whatever, we wear smokes. So if you lift the ban on wearing smoke, what is the guarantee that people who will be coming in with wearing smokes will not have weapons hidden in their smokes, inside their smokes? So common sense should tell the regional minister, the regional security council, and the national security council that the ban on wearing smoke need to be continued. And then also the audio that I played, whereby some individuals, kusasis, were saying that they will kill mamprusis, they will create conflict in Bawku after the Saman paid, should be taken seriously, ladies and gentlemen. I don't want anything to happen, and I come here talking through to powers, and then you will not understand. All right. Sumbere said, you have not spoken about the recent High Court ruling between Sule Afoli and Abogrago. Or to be very honest, I don't have any information about that. You can share it with me, please. I don't have any information about that, Sumbeda. All right, so ladies and gentlemen, I think I will end here and hopefully come tomorrow to continue with discussion on Bombande. We shall continue with our Bombande. I hope you guys had a happy Bombande's Day yesterday. You can share with me your feelings. You can share with me how you enjoy